Hi, this is Dr. Tracey McCarthy, psychologist, attorney, and educator. Welcome to our new channel. Today we are going to address the topic of insanity. This issue comes up quite frequently in high-profile criminal cases, and it is a forensic issue that is steeped in much confusion and wrong speculation. So we're going to explore what insanity is all about and the reasons for its assertion in criminal trials. First, contrary to most thought, insanity is not a psychological or medical construct or term. It is a legal construct that must be proven in a court of law. The insanity defense is a defense in a criminal case. It is officially known as not guilty by reason of insanity. Now, what this means is that the person is not saying that they did not commit a crime. They are asserting that they should not be found guilty of the crime due to insanity. The defendant is asserting that he or she is not responsible for his or her actions due to a temporary or enduring psychiatric or psychological challenge at the time of the crime commission. Now, around the world, there are varying legal definitions for insanity, and as pointed out in an earlier video on defining psychological disorders, the definition of psychological disorders also varies across cultures. Crime generally requires a mental component known as the mens rea and a behavioral component known as the actus reus. The mens rea, or what some refer to as the guilty mind, is the culpable mental state to commit the crime, and the actus reus is the actual behavior or action of crime commission or omission. While psychologists and psychiatrists are involved in providing evidence regarding the issue of insanity, neither are allowed to make the legal determination of insanity or to testify directly to such. Neither are allowed to testify as to whether or not the defendant is actually insane. That is the job of the jury as fact finder or the judge after a review of the evidence on the issue of insanity. The most popular standard for determining insanity comes from the Model Penal Code. This attempts to balance out the older McNaughton rule and the older Durham rule on the insanity defense. The Model Penal Code is pretty straightforward. It looks at, was there a disease or defect of the mind that rendered the person incapable of appreciating the wrongfulness of their behavior or conforming their behavior to the dictates of the law? Now, this is all examined in past tense, as the state of mind during the commission of the crime is what is at issue, not the state of mind during the actual trial. Hence, a person might have been technically insane at the time of the crime and sane at the time of trial. This is often referred to as temporary insanity. While any psychological disorder might technically serve as the basis for considering the issue of insanity, disorders related to psychosis or problems with reality, intellectual disabilities and developmental disabilities, and affective or emotional regulation disorders tend to be the disorders frequently used in criminal cases wherein the insanity defense has been raised. Any disease or defect of the mind, however, can be offered to support the defense. Okay, that is a general look at the issue of insanity and the insanity defense. We hope you found the material helpful, and we thank you for stopping by. We look forward to seeing you again soon.